be around the sale of immovable property involving deceased estates. And I think, guys, this is one of those subjects where I think it's important to understand, and I think that you probably need a little bit of a broader knowledge around deceased estates, because you know you obviously get called in to sell properties, and some of those properties are going to be deceased estates, and and there's various parameters within the deceased estate process as to whether it's hard or difficult, or possible or not possible to actually to actually be in a position to sell the property. And there's quite a few pitfalls that I've seen over the years as well, that kind of happen, and that I think that you really need to be aware of, so as not to sort of get yourself into trouble, and to present yourself as someone who understands the process. So there's different kinds of estate transfers. In my mind, I've identified three different kinds of estate transfers. One of them doesn't involve you guys at all, because it's not a sale, it's a transfer pursuant to the deceased estate. And the other two are sales of deceased estate property, which I think that obviously there's a sale involved, and you guys need to understand. So what I've done is I've put together this little diagram, and this is an absolute simplification of the deceased estate process. Um, so you can see moving from the top left, someone becomes deceased, someone dies. Once that person dies, we need to report the estate. Once we've reported the estate, there's letters of executorship getting issued, and the job of the executor is to drop an L&D account. So I just want to slow down a bit and maybe go through some of those processes, right? Um, so first of all, let me say that this process, from someone dying to actually transferring the property to the heirs, you know, just with the state of the master's office, the ability to react, to find the files, it's going to take you, I'd be impressed if it was under 18 months. Maybe if you really, that's all you have to do, and you just drive down to the master's office yourself, you can get done a little bit quicker. But I've really found it to be a very laborious process. And I think what's sometimes complicated, guys, is that a lot of people try and do it themselves. A lot of people try and do it themselves. So it's someone dies, and then they try and wind the estate up themselves. Or there's just various parameters, and I think we need to try and understand them. So first of all, what happens, just to go back and take it a little bit slower, we have someone who dies, we have the deceased, that person dies. So once they die, right, their family gets together and they need to report the estate. Now, people can die testate or intestate. If they die testate, it means they're dying with a will. Now, the will then dictate who becomes the executor, and the will then dictate who are the people who are going to inherit from the person who died. Okay? Or they can die intestate, and intestate simply means they've died without a will. And if they die without a will, well, then the question is, who's the executor and who's going to inherit? Well, who's the executor? Normally, what still happens is a family member or somebody that the family knows will, as part of the reporting documents, apply and ask the master to be appointed as the executor in the estate. Okay, so that's something that's relatively easy to overcome. It's obviously easier if there's a will and we're appointing the executor in the will. That's the easiest way to go. But it's not to say that there's no will. It's a disaster. It's not a disaster. We can still have an executor appointed. And of course, who inherits the property? Well, we need to turn to a piece of legislation called the Intestate Succession Act. So it's a piece of legislation that's been around for a very long time. And essentially what it does is it drills down into your family relations, and finds out, if you die, who's left. So, for example, if I die and I have a spouse only, well, my spouse will inherit. If I have a spouse and children, well, then my spouse and my children are going to inherit. And the current law is they're going to everyone's going to get a child share, or 125,000 Rand, whichever is the greater. So the children and the parents inherit. If I have no spouse and I have no children, well, then it goes to my parents. And if both parents are around, they inherit equally. If only one's around, they inherit. Then that one spouse inherits, alone. If I have no children, no spouse, and no parents, well, it goes to my siblings. Okay. And if I don't have any siblings, it goes to my cousins. And if I don't have any cousins, it goes to my second cousins. And so it goes. What we do is we drill down in the, according to our bloodlines until there's no one left. And there's no one left, well, then, unfortunately, the state is the state is going to inherit, which is not an ideal scenario at all. But that's what's going to happen. So part of reporting the estate is we put together a whole bunch of documents, and the master's office and of course this is all governed by the Administration of Deceased Estates Act. So we put together a whole bunch of documentation. And I'm not going to go into the details of the documents, but there's prescribed documents, that there's an initial inventory, etc., etc. You put together your documents and you report that estate. And reporting means you write a letter to the master. And by the way, you must have, if there's a will, you have to have the original will. And guys, this is why it's so important. When you draft a will, I normally get 2 or 3 copies, original versions of the will signed, so that when the person dies, there's always going to be an original. So we put together documents with the original will, and we submit to the master. Now, there's a trick here, guys. If I report the estate to the master and I simply go and deliver my documents at the master's office, I'm going to wait 2 to 3 months at least to get my letters of executorship. And I think that's what some of the bigger financial institutions do. They don't use runners. They just put the documents together and deliver it to the master. If, of course, you're prepared to spend some money, you can spend about 1,800 Rand. You can use a runner, a master's office consultant, who takes the documents to the master's office for you, and then you should have your letters of executorship within approximately 2 weeks. Now, I have an example of a letter of executorship in one of my slides coming up, and I'll talk more about the importance of the letters of executorship. But once the letters of executorship are issued, now there's somebody is authorized to assume control of this estate. And the job of the executor, guys, is really to collate the assets and the liabilities of the estate, to advertise for creditors, to open up an estate-led banking account, and to see what does this person own and who do they owe money to. And what we do is we essentially take the assets and the liabilities and we culminate all these assets and liabilities in what's called a liquidation and distribution account. Okay. Once we've done the liquidation and distribution account, again, there's a whole bunch of admin that needs to go through. You must submit your L&D account to the master of the High Court. The master of the High Court going to approve your L&D account. Once, and remember, guys, this is again sending documents up and down to the master's office, waiting for them to respond. They take ages to do so, but you do get there. You get your L&D account approved. Once it's approved, now it must be advertised and it must lie for inspection. So it's advertised in the Government Gazette and it lies for inspection at the local magistrate's office or at the master's office for a period of 4 weeks. Once you've done that, you submit more documents to the master's office to say, well, it's laid for inspection, free from objection, and you ask for the permission to start paying out. And amongst that, guys, there's also, pre-death tax clearances and post-death tax clearances, which also take a long time to get. If your estate's worth over 3.5 million Rand, the process of getting your post-tax death clearance certificate from SARS also takes a bit longer because it's more complicated as an estate due to be a estate. But once you get all through those things, what you can do is you can report this. You can now start, passing the assets on to the heirs. Look, in practice, often cash and other bequests are handed out a bit earlier than this, as long as it's safe to do so. But for the transfer of immovable property, well, now you've got to transfer it in terms of the liquidation distribution account. So if just from this very simple diagram, there's 3 kinds of transfers that I'm going to identify. The first kind of transfer is where we transfer the property to the heirs, right? So person A dies, they bequeath an immovable property to their spouse or to their children, and the executor goes through this process of winding up the estate, culminating in the L&D account, and that L&D account being approved. And once it's all done, now we need to give effect to the L&D account. Now, what we do is we transfer the property to the heirs, the people who've inherited that property, and that's a deeds office process, right? The second kind of transfer is where the heirs say to you, I've inherited the property, but I don't want the property. I now want to sell this property. I call you in as an estate agent and I tell you, I've inherited a property. I'm going to sell the property to somebody else and I want you to market the property for me. In this case, the heir, the person who's entitled to the property, is going to be the seller of the property, and you're going to find a buyer, and we're going to go through that in more detail in a moment. Your third kind of transfer is the simplest and the best transfer, guys, and that is when the executor sells the property out of the estate. Okay, and we'll cover that as well. Now, in amongst this process, right, from becoming deceased to having your liquidation distribution account approved and having approval to pay out, it's obviously a long process, and you may be called in by either the executor or the heirs at any point during this process. And it's important for you as an estate agent to identify at what point are you being called in, because it does make a material difference, and it's going to have an impact on how you handle the transaction. And remember, guys, one of the offers that we do make to you is that if you come across a deceased estate, you're always welcome to call us, and what we'll do is we'll call the executor and we will have a discussion with the executor on your behalf to find out where are we in this process, what is the best way to go, and what is the most efficient way to do this. So just moving on, I just want to show you guys, this is what the letters of executorship look like, right? So it's in terms of section 13 and 14 of the Administration of Deceased Estates Act. You get an estate number, and it certifies, in this case, Michael Dick is appointed on behalf of his father, Thomas Dick, who died on the 14th of May 2019. It's signed by the master. It's issued in Johannesburg, and there, of course, there we have the master stamp, so we can see the date of the stamp. Now, I'll come back to these in a moment, but guys, these are the really, really important documents that you need to sort of understand and know and to get. So let's just look at this first, and I've covered some of this slide already, but transfer of a property to an heir of deceased estate. This is property transfer number one, and it does not involve an estate agent. So this is where, as I've said before, where somebody dies, the property is inherited. The master appoints the executor. The executor's function is to wind up the estate, draft the LD account, and then must then distribute the assets. Okay. We can only transfer this property, guys, and I think this is an important point to understand. We can only transfer the property to the heir once the liquidation distribution account has been approved. So in other words, if it's going to take us 18 months or 2 years to wind up the estate after the person has died, I can only transfer the property to that person right at the end of that process. And to the extent that the heir wants to transfer the property, great, then that's no problem. There's no sale, there's no estate agent involved, that's fine. But to the extent that the heirs or the executor want to sell the property, or the executor has to sell the property to get some liquidity into the estate. And guys, this is, sorry, just as a side note, this is all about estate planning, right? If you want to leave your assets to, if you have a property and you want to leave it to your children or your spouse, you need to plan properly. You need to make sure that when you die, there's enough money to pay the bond. There's enough money to pay all your other debts, including estate duty or executor's fees. Because if you don't have enough money, guys, the executor is going to take the property and say to your heirs, we must sell the property to realize money to pay the debts of the estate. And suddenly you'll find that the people that you intended to benefit are not going to benefit from the property at all. What's also important is that if this process, and let's say it's an 18 months to 2 years process at least, during that process, if there's no one living in that house, it's a massive waste of money. And this is why it's a good idea if nobody wants the property, the executor must rather sell the property from out the estate, which is to our advantage because now we have a sale. But remember, during that 18 months, there's repairs, maintenance, electricity, water, rates, taxes, levies, etc., etc. So if the decision is to sell the property, the sooner the sale takes place, the better. It really is to everyone's advantage. The next kind of transfer, guys, is and that's transfer number two. And this is an extension of transfer number one. So this is what happens when when the executive says, I'm not going to sell the property. You as the heir are going to take transfer of the property. Now, what happens there is the heir takes transfer, is going to take transfer of the property, and that transfer hasn't happened yet. It's still going to happen in the future. That heir approaches you as an estate agent and says to you, listen, I have inherited a property from a deceased estate. I would like you to sell this property to somebody else. I would like you to sell the property. Now, I want you to market the property. Now, this is possible, guys. This is possible because what we can do is we can transfer from the estate to the heir and from the heir to a purchaser simultaneously. It's possible. It's not the best route to go. The better route to go is rather to get the executor to sell the property and then rather have the proceeds of sale go to the heir. But sometimes the wills are drafted in such a way that this is not possible. That, for example, if the executor sells the property, the proceeds go into the residue of the estate, and the person entitled to actually inherit the property just shares in the residue and doesn't get the full value of the property. So sometimes, for technical reasons, it's not possible to do it the easy way, and we must transfer the property to the heir, and from the heir we sell the property to a third-party purchaser. Okay, but now, guys, the heir is only entitled to the property once the master's approved the L&D account. Okay, prior to this point, the property has not in law invested in that person. So if you draft a sale agreement, you're welcome to call us. What I would do is I would make the agreement subject to the liquidation and distribution account being approved by the master of the High Court, and subject to the subsequent consent by the master to allow the executor to transfer their property to the heir within a specified time period. So I think that, really what we need to try and do here is be really cautious. And let me just give you an example of how this thing goes really, really wrong, right? The transfer process here is a delayed transfer process, because what's going to happen is you got the deceased dies. I'm looking to 18 to 24 months before I can transfer to the heir, and then I can transfer simultaneously to my purchaser. So what typically happens here, the heir will come to you and he'll say, I need you to sell this property. And you'll say, great, I don't know deeds of search. I see you don't own the property. No problem. I've inherited the property. I've spoken to the executor. The executor tells me that transfer is going to take, that I will be able to transfer the property within the next 2 to 3 months. So you can go ahead and market the property. We'll transfer the property from the estate to my name, from my name into the heir's name, into the third party buyer's name simultaneously. Now, the trouble there is that executors are sometimes overly optimistic as to how long this process will take. So they tell the heir it'll take 2 to 3 months. It's actually going to take another year. So now what you do is you go out and you sell the property to a buyer, all right? And the buyer is now invested in the property, and you write into the offer the purchase. You say, subject to the liquidation distribution account being approved, subject to the master giving the go to transfer the property, and we record that the seller is not the owner. He's going to take transfer in terms of the deceased estate, and we'll do a simultaneous transfer to the buyer's name. So you're making full disclosure. And again, guys, please call me and I'll help you with that wording in your offer to purchase, right? So the difficulty then is that we have this massive delay because we haven't been accurate enough as to when our transfer is going to be finalized. Okay, so in this process we must be careful. And I recall a few years ago exactly this happened. Thank goodness I wasn't the conveyancer, but what did happen was that the buyer was allowed. So everyone thought it'll go really quickly, the transfer. So the heir, who was now the seller of the property, said to the buyer, listen, it's a deceased estate, transfer's going to go through within 2 to 3 months anyway. Why don't you move in? Because we need someone to look after the property anyway. And once you've moved in, don't worry about paying occupational rent. Just pay the electricity and water, because it's going to be a really quick process anyway. And what happened in this case, the buyer moved in and transfer took another year. So during the course of that year, the buyer paid no occupational rent, and it created a massive problem because there was this delay, and eventually there was a dispute because the heir wanted payment of occupational rent. The executive got involved, and it just became unpleasant. So the one really trying to communicate to you guys here is when you do this kind of transaction, you must understand the parameters within which you're working. We must talk to the executor. We must get a realistic assessment as to how long transfer will take, and we must make full disclosure to our buyer that this is going to take longer than usual. So the buyer's on board with us, that he doesn't try and cancel the transaction at a later stage. Okay. So having regard to those complexities and all the clauses within a certain agreement, of course, what's easier, guys, is that the executor simply sells the property from the estate to a third party, and that is then our transfer number 3, right? Okay, so somehow I think I skipped. Right, so here it is. So the third kind of transfer is sale of a property from a deceased estate directly to a purchaser. Now remember, guys, what's happening here is the executor is acting as the seller on behalf of the estate. Now, let's pause here. What is so critically important about understanding this process, guys, is that your executor can only act as executor once they are in possession of letters of executorship from the master of the High Court. So you recall my earlier slide, I showed you those letters. That's what they look like. Now, what happens here, guys, is that sometimes what happens is, you know, say, for example, dad dies, mom comes to you, or son comes to you and says, listen, I have been appointed the executor in my father's estate and I want you to market this property. What is he really saying is, the will appoints me as executor. So I'm the executor in waiting. I'm not the executor yet. I haven't been appointed by the High Master of the High Court yet. I'm going to be appointed, but I'm not yet appointed. Now, the difficulty here is you can't enter into an agreement of sale until the executor is appointed. You can start marketing that property, but you can't enter into an agreement of sale, a valid agreement of sale. So bear this in mind. I mean, I spoke to a client yesterday. Agents want to sell the property. It'll go very quickly, but the seller is not appointed as the executor yet. We need to wait for those letters of executorship first, right? Where there's more than one executor, please get all the executors to sign a resolution or to sign your sale agreement. Please, guys, you must do a deeds office search, because you often find a scenario where husband and wife own property together, and I'm using the husband as an example. Husband dies and wife is left behind. Now what's going to happen is executor is going to sign for husband, the executor in the estate of the late Joe Bloggs, and Mary Bloggs. So husband is the executor representing him, and wife has herself. She represents herself. Okay, and then they both get an offer to purchase. Now, as I said before, the executor must be appointed by means of letters of executorship, and this requires Section 2.1 of the Alien National Land Act, right? Which basically says that the when you enter into agreement of sale, you must be authorized in writing. The executor gets authorized in writing by virtue of the letters of executorship. So one of the the transfer of a property where the property is sold by the executor to a purchaser should not take extraordinarily long. I've come across in the past agents and conveyancers who tell me know that it takes many, many months because we must wait for the liquidation distribution account to be approved. This is simply not true. Where I sell from an estate and the executor is the seller of the property, and I'm selling to a third party purchaser, that transaction goes through in the ordinary course. You can maybe add on 3 to 4, maybe 5 weeks onto your transfer process. And the reason why we want to do that is I need what's called a Section 42(2) endorsement. Okay, so what happens is the master must issue a certificate, which is in terms of Section 42(2) of the Administration of Deceased Estates Act. So in practice, what happens is the master doesn't actually issue a certificate, he rather stamps the document. So what happens here is I take my power of attorney and I take a whole bunch of supporting documentation and I deliver this to the master of the High Court. The master, and this little in blue here, the certificate I hereby certify in terms of Section 42(2) that there's no objection to the transfer as stated herein, and it's signed by the master. So what happens is that stamp goes on the back of the power of attorney, right? And we lodge that in the deeds office. The deeds office then knows that this is approved by the master, and I have to have this endorsement from the master. To get this endorsement, I submit the power of attorney, and I also submit a further document which which is a it's consent. So there's a bunch of information that the master wants. They want to see the sale agreement, they want to see the power of attorney, etc., etc. So there are accompanying documents. And sorry, guys, just go back to my previous slide. This is why in these estate transfers, we always are going to have the clause that says this agreement is made subject to the consent of the Master of the High Court, right? We need to have that in our agreement. We don't generally put a timeline to it because it's hard to sort of estimate what it's going to be. Guys, just a few closing comments on this issue of the 42.2. I need the consent of all the major heirs in the estate. So in other words, if you're going to sell property and you have an executor, you must just double check with the executor that there aren't like four siblings who hate each other and who aren't going to agree to the sale of the property. I need the consent of all major heirs in the estate. So anyone who's going to inherit the, and when I get my 42.2 endorsement, I need to get a written document from those heirs saying we consent to the transfer of the property. Okay. So this middle paragraph here, again, I'm just emphasizing this point that if you have an estate that transfers from 0 to 24 months and you're going to sell the property anyway, circumstances are going to dictate that it's probably better to sell the property earlier in the process so you can avoid the rates and taxes and maintenance. But you guys need to ascertain, where are we in this process? Is it possible now to sell the property, or has the process simply moved that much further on? Has the process moved that much further on that that it's better to simply sell from the heir to a third party purchase? And again, that's kind of an assessment that we need to try and make sense of. And of course, guys, once this transfer process is finalized and registered in the deeds office, as conveyancers, what we do is we pay the money into the estate date banking accounts. If it's owned by the deceased spouse and a surviving spouse, I'll pay half into the estate aid banking account and half to the surviving spouse, unless they were married in community property, in which case I'll pay both. So, guys, in conclusion, and Michelle, I messaged you. I thought I was going to take a bit longer. It looks like I haven't taken. I've taken a bit longer than I anticipated. So apologies. In conclusion, guys, deceased estate transfers are not rare. They happen often, but you must have regard to the particular circumstances of the deceased process and the heirs, and how far the winding up process has progressed. We have to speak to the executor, which is sometimes easier said than done, because sometimes it's the financial institutions that are a bit more harder to deal with. But please do call it upon us to help you. We're more than happy to assist you in the process as we go through it. Right, guys, that's me. I hope I've given you some ideas as to how how these work. Always remember to please reach out to us for help if you need. And yeah, let me just say in closing, thanks so much for the support we get. It's always massively appreciated. And yeah, thanks very much.
Marius, there was a request from Stanley. If you could send a email with a suggested subject to master's consent clause.
Yeah, no problem. You can do that.
Super. Thank you so much, Marius. Thank you always for your input. I think